So here we are, succession. So really, absolutely very important part of what we're looking at as an entire course. In other words, you're looking at, could have on a good day 2 questions or 3, 2/3 practically of the course from here. There's 2 straightforward. There's a split in succession as it's asked. The first is what we might call the formality side of it, and the second is the structural application side of it. So we tend to have the first bit is simply what's the will, how does the will get structured, what's the sort of elements within it, what's the legal right share, what constitutes the general construction process, certainty, the formal requirements, signatures, witnesses, all of that stuff. And the second half is the operative element. The children taking an application because they don't feel they have received a satisfactory outcome in relation to it. The interpretation of the will itself in the probate structure. The legal right share and all the intricate elements related to that. The concept of appropriation. So burning wills and all kinds of elements to it. So we've got the structure of the will up to getting it up and functioning, and then the functioning of the will. And you get the 2 questions like that, looking at this split, and then sometimes you get a happy 3rd question where there might be something on intestate succession or something like that. That tends to come. It's only come 1, 2, 3 times. So we've only had that 2 or 3 times over sort of the 10 or 12 paper period. But it does and can happen. So succession. We have a couple of little quotes there, which I just put in just to give a little zesty interest to this. And most peaceful marriages upon mingled motives between convenience and inclination, but it's concern for family members that made the magitarium, the original entail, and the use. All of what we've seen so far is really what I'm saying. Up to now, we're looking at land law in this obscure sort of slightly methodical approach, just going through it. But there's a psychological element to it, and here we reach the psychological element, and that is, what was all this about? What's land all about? A huge part of land owning and the dealing with land is about status and concern for one's family. We are physical entities and we occupy physical space. It is part of the innate human drive to carve out a place of comfort and security for ourselves and our family and our offspring. So this primordial idea of taking care of our people is really what a lot of land ownership is about. The drive to own a house, which is frowned upon daily when you're reading it in the papers, can we not have people just occupying a house? People want to own it. It's because over hundreds and hundreds of years, tens and tens and tens of centuries, thousands of years, we found that if you own something, if you own the piece of land, you can stabilize and secure your family over a longer period of time than if you were a transient connection to it. And the drive to hand on the bit of property that you got to the next generation has been there from the beginning of the common law. But it has always been stymied. There's been a very high tension in the class structure to try and prevent property moving away from elite classes to lower classes. And so the feudal system denied anyone except the crown the opportunity to automatically present the work of their time to the next generation. Even earls, when they die, the property goes back and is regranted through the process of the feudal system to the next heir, to the next person in line, who is really the next person to hold from the crown. So the drive to get the will was right there at the very beginning, and to determine what happened to your land. The little quote I put at the beginning of this is to show that the feudal system took care of the king's interest in making sure that he had somebody that he believed and trusted in to look after the piece of land after you died. That's your eldest male child. It was a militaristic society, and so it went to the eldest male child. But that was the king's interest. You, as a parent, as I say here, you as a parent had an interest that went beyond that. So just at the beginning there, it was the concern for the lesser members of the family. And lesser in that is meant really in this sense of, in the medieval understanding, in the feudal conception, of second and other children, of non-male children. It was the concern for lesser members of the family that made entails of the eldest son unsatisfactory, and that required portions to be laid out in settlements for children who were not to inherit the estate. There is in no way of putting the legal developments into a coherent framework except through the assumptions that landowners cared for all the members of their families and were determined to provide for them, although certainly not equally. Landowners were then involved from the earliest of times in balancing the natural family sentiment and a growing